Hi and welcome to the Law Center. I am your host, Larry DeMarco, and today we are here with Leon Koziol. He is a constitutional scholar and he practiced civil rights law for over 23 years. Leon, thank you for being a repeat guest on my show.
Honor to be here as always, Larry.
Leon, we have been discussing judicial immunity that needed to be scaled back, and the current events lead me to ask you, should we be looking at police immunity? First, before we begin, Lee, what is immunity for our listeners?
Well, there are different forms of immunity. There's a thing called absolute immunity, which applies to at least three typical categories are absolute legislative immunity, absolute prosecutorial immunity, and absolute judicial immunity. Those immunities prevent people from bringing lawsuits against those individuals because under this judge-made policy known as immunity and its different types, it's designed to allow decision makers and prosecutors to have discretion without fear of being sued, and therefore causing less the qualified people from seeking those types of offices. Now, there's also qualified immunity that typically applies to law enforcement individuals, be it police officers, deputy sheriffs, even IRS agents. There's different, when they're enforcing the law, they don't have the full immunity as the other categories I just mentioned. You can bring an action against them if you can show that they were objectively unreasonable in the procedures that they employ to inflict whatever wrong that the victim is seeking to have accountability over. And in this current crisis, accountability is at the core of the problem, because if there's going to be any discussion about getting people to the table, as you mentioned, by getting this whole crisis resolved, then victims across the country have got to be convinced that there will be accountability. And scaling back immunity is a major step in that direction.
Do lawsuits as a deterrent work to limit government misconduct?
Well, lawsuits under the Civil Rights Statute of 1871, the Civil Rights Statute was, the Supreme Court gave it life in 1961 in the case of Monroe v. Pate, and that set off a whole series of lawsuits where aggrieved parties, whether it was police brutality, wrongful discharge, discrimination, were able to bring lawsuits against their employers or their assailants or wrongdoers and obtain monetary recovery. That's the one way that instigates policy changes. There's a reaction to lawsuits, for example, that I brought. I've obtained hundreds of thousands of dollars in judgments. They're typically on behalf of racial minorities, women, sexual harassment, those types of cases, and they were effective in getting the wrongdoers to change their ways, to have their enforcement personnel held more accountable. When you limit those lawsuits, or typically when judges and others find countless obstacles in the way of that lawsuit, ultimately landing them into a dismissal or abandonment of those lawsuits, you lose that sense of accountability. The judge can, even one who is following in law, can easily manage the case to go whichever way that judge wants it to go. And so these are some of the accountability problems that I've been seeking to correct.
Across the broad spectrum of society, is the law on the books enforced? And if not, what can we do to make a change?
That's the big issue, Larry. They're not always enforced, or at least properly. When we bring the lawsuits I brought and obtained hundreds of thousands of dollars of recovery for the victims, it caused accountability. It caused changes in policy and practices, disciplinary activities to prevent those types of lawsuits, because when you pay money, you're compensating the aggrieved party. And these lawsuits I brought have managed to do that. But when I turned my attention to the corruption in the judiciary, they retaliated. As a judicial whistleblower, I brought out corruption against my profession. It was a conscientious stand, and then they acted to suspend my practice privileges, They went after my parent-child relationships, and this is what typically happens to judicial whistleblowers who have no legal protection as the laws are currently on the books.
For this discussion that we need to have involving police misconduct and judicial misconduct, how do we bring scaling back immunity into the discussion and get lawmakers to scale back immunity so that we can sue for malicious conduct and have it easier for victims of police brutality to sue?
Well, they've given, the laws go back and forth, conservative to liberal, depending on which the composition of the Supreme Court is, and it's this political nature that harms the public. Because from 1 year to the next, the laws are changing. In the case of quasi immunity, qualified immunity, as you point out, there was at one time the immunity for enforcement officers, where if they acted maliciously to harm someone, they could be held liable. Then they shifted that to make it objectionable, a more objective standard to measure whether or not they get that immunity. And so they could even act maliciously, still get their immunity, and get away with what they're doing. And so we need to get back more into letting the jury, letting the court decide whether in a given situation that officer was acting within his or her scope and acting properly. Once you start giving them immunity protections, they act accordingly. They act with ill will, and I think that's wrong. And obviously, that led to the murder of George Floyd.
So what can we do to make this happen? What can we do to scale that back? Do we want a law, or do the laws that we have need to be better enforced?
I think we need accountability, Larry, and that is a combination of things you mentioned. I think what you see out there today is that time and again, people were not held accountable. And they were promised change, they were promised reform, and then things like this keep happening. And so what's happening is that people are taking the law in their own hands. They're protesting beyond what we consider acceptable First Amendment expression. And they're doing that because they don't believe that if they follow the channels in our courts, that they will receive justice. It's the injustices that are so routine in these courts that is causing the current, backlash. And I think we're going to not see this change until the public is convinced that people like Michael Schlager, Devin Chauvin and Derek Chauvin and others are held properly accountable.
The other way I want to add, because I'm big with social media, is I believe that we should ourselves be watchdogs, that we should all watch, network with each other, and bring awareness.
Here's the thing. When we talk about watchdogs, it's a good point. But when you're a person like me who exposed corruption time and again, and then they targeted me, the witch hunt and all of that, it's hard to hold accountability when you are conducting witch hunts and retaliating as they did to me for exposing the corruption and trying to correct it. As a civil rights attorney, when I was practicing and winning all these lawsuits, they eventually took me out. Now that's what I mean. It's that sort of wrongful reaction that's not being held accountable that is causing these people to react violently and in a manner that we as a society do not approve.
Lee, let's leave it there, and I want to thank you for being a guest at the Law Center.
Thank you, Larry. Have a good day.
Like, subscribe, and click the notification bell for new videos. To learn more about my legal services, click the links in the description section of this YouTube video or on one of the video links on your screen. Thanks for watching. Bye for now.